The conference room sits silent now. Empty coffee cups line the mahogany table. Like Manhattan glitters in the late afternoon sun, indifferent to the storm that just passed through these walls. 23 floors below, life continues. People hail cabs. Street vendors call out. The city breathes, unaware that in this very room, 17 words buried on page 7 of a 147-page contract just reversed a verdict worth $83 million.
Dana Brooks stands at the window, her reflection ghostly against the skyline. 3 hours ago, she was certain. Victory felt inevitable. The evidence was overwhelming. The emails were clear. The intent was documented. Every legal principle supported her client. But contract law has a way of humbling even the most prepared attorney, because sometimes the law cares less about what you meant to say and more about what you actually wrote. And what was written on page 17 changed everything. This is the story of Harborline Logistics versus Northbridge Holdings, a case that began as a straightforward breach of contract claim and ended with a legal principle so obscure that most practicing attorneys have never encountered it. A case where the difference between millions gained and millions lost came down to whether a court would look beyond the four corners of a document. A case that asks a question as old as contract law itself. When two parties shake hands on a deal, what truly binds them? The words they spoke, the promises they made, the understanding they shared, or only the sterile language that survived the final draft? The answer would surprise everyone in that courtroom, including the judge. Act 1. The deal that wasn't the promise. To understand how 17 words could matter so much, we need to go back. Back to where this story really begins. Not in a courtroom, but in a different conference room, 18 months earlier, where two companies were building what they believed was a partnership. Harborline Logistics had been a mid-tier shipping and freight company for 23 years. Regional presence, solid reputation, the kind of company that never made headlines but always delivered. Founded by Thomas Harborline in 2002, built from a single warehouse in Newark into a network spanning 7 states. Not glamorous but profitable, dependable. The backbone of American commerce that nobody thinks about until something goes wrong. Northbridge Holdings was different, a private equity firm with deep pockets and aggressive strategies. They specialized in what they called operational partnerships, which meant they'd invest capital in exchange for equity and control over certain business decisions. They promised expertise, infrastructure, access to markets that companies like Harborline could never reach alone. They made it sound inevitable: grow with us or get left behind. The initial meeting happened in May. Spring sunlight flooded the conference room. Thomas Harborline sat across from Marcus Venn, Northbridge's senior partner. Between them, the outline of a deal that could transform Harborline Logistics forever. Northbridge would invest $42 million. In return, they'd receive 35% equity and seats on the board. But here's what mattered most to Thomas. Northbridge also promised to connect Harborline with their network of West Coast distribution centers. That access alone was worth millions in potential contracts. Marcus Venn spoke with the confidence of someone who'd closed 100 deals like this. He talked about synergies, vertical integration, market positioning, but Thomas wasn't interested in jargon. He wanted specifics. Would Northbridge guarantee access to those distribution centers? Would they commit to routing at least 25% of their West Coast freight through Harborline? Marcus nodded. That's exactly what we're offering. You get preferred vendor status. First right of refusal on all West Coast logistics. It's why this partnership makes sense. No contracts existed yet, no lawyers in the room, just two businessmen sketching out terms. Thomas asked the question that would later haunt this case. And that commitment, the West Coast access, that's going to be in the final agreement? Marcus didn't hesitate. Absolutely. That's the whole point of the deal. They shook hands. The negotiations. What followed was 6 months of negotiations. This is where deals get complicated, where handshake promises meet legal reality, where armies of attorneys descend to transform human conversation into contractual language. Dana Brooks entered the picture in June. She'd been Harbourline's outside counsel for 11 years. Commercial litigation was her specialty, but she handled transactions too. Good attorney, thorough, the kind who read every footnote and questioned every term. Thomas trusted her completely. On the other side was Northbridge's legal team, led by a senior partner named Richard Wolfe. Big firm, big ego. They sent over the first draft in July, 128 pages. Dana started reading. The structure was standard for this type of deal. Investment amount, equity percentage, board composition, voting rights, non-compete clauses, confidentiality provisions. Everything you'd expect. Dana read through the operational sections. Distribution, logistics, vendor relationships. She stopped. The West Coast commitment wasn't there. Not explicitly. There were vague references to cooperation, language about exploring opportunities, but nothing concrete, nothing that guaranteed Harbourline the access Thomas had been promised. Dana drafted an email to Richard Wolfe, professional but pointed. The West Coast distribution commitment discussed in preliminary meetings needs to be explicitly included in Section 8. Please revise. Richard's response came 2 days later. The parties have agreed to work cooperatively on distribution opportunities. We believe the current language captures the intent. Dana pushed back. She drafted specific language. She proposed an amendment that would obligate Northbridge to route a minimum of 25% of West Coast freight through Harbourline for the first 3 years of the partnership. She sent it to Richard with a note. This reflects the terms Mr. Venn outlined in May. The revised draft arrived 3 weeks later. The specific language was gone. In its place was a sentence buried in the middle of Section 8. Northbridge may, at its discretion, utilize Harbourline services for distribution and logistics operations where operationally feasible and commercially reasonable. May, at its discretion, where operationally feasible. Every word designed to create wiggle room. This wasn't a commitment. This was a suggestion. Dana scheduled a call. She needed to understand what had changed. Richard Wolfe was smooth. He explained that Northbridge's board had concerns about binding commitments to specific vendors. They needed flexibility. Market conditions change. What if Harbourline couldn't handle the volume? What if rates weren't competitive? They needed discretion. Dana pushed. But Mr. Venn specifically told my client that West Coast access was guaranteed. That was a material term. Richard's tone shifted slightly. What was said in preliminary discussions and what makes it into the final contract are often different things. I'm sure your client understands that business conversations are subject to final documentation. This is where the case really began. In this moment, this conversation, because Dana faced a choice. She could walk away from the deal, tell Thomas that Northbridge wasn't honoring their commitment, risk losing a $42 million investment. Or she could trust that the relationship would hold, that even if the contract didn't explicitly require West Coast access, Northbridge would honor the spirit of the deal. She drafted another email to Richard, this one firmer. She wanted the commitment in writing, or the deal was off. Richard called her directly. He was apologetic, understanding. He explained that Marcus Venn was traveling, but would call Thomas personally. They'd work it out. The contract would reflect their understanding. 3 days later, Marcus did call Thomas. The conversation was brief but reassuring. Marcus confirmed that nothing had changed from their May discussion. Harbourline would get West Coast access. He understood Thomas's concerns. The lawyers were just being careful, covering every angle, but the deal was solid. They'd honor their commitments. Thomas called Dana. Marcus gave me his word. Let's move forward. The signature. The final contract arrived in November, 147 pages. Dana had reviewed 8 drafts by this point. She knew every section, every clause, every comma. She read through it one more time. The West Coast language still wasn't explicit, but it was there, sort of, in that discretionary phrasing in Section 8. She looked at Section 12, standard stuff, definitions, dispute resolution, governing law. And then she saw something she'd seen in dozens of contracts before, a clause so common that attorneys barely notice it anymore. It sat there on page 17, unremarkable, 9 lines of text in the same Times New Roman font as everything else. This agreement constitutes the entire agreement between the parties and supersedes all prior negotiations, representations, or agreements, whether written or oral. No party shall be bound by any prior representation or promise not expressly set forth in this agreement. This agreement may not be modified except in writing signed by both parties. An integration clause, also called a merger clause, standard boilerplate. Every lawyer knows what it means. It says that the written contract is the whole deal, nothing before it matters, not the preliminary discussions, not the handshake promises, not the phone calls or emails or commitments made in good faith. If it's not in the written contract, it doesn't exist. Dana had seen 1,000 integration clauses. She'd drafted hundreds herself. They're protective. They prevent parties from later claiming that verbal promises should override written terms. They create certainty, finality. They're supposed to prevent exactly the kind of dispute that was about to consume the next 2 years. But here's what Dana didn't fully consider in that moment. An integration clause doesn't just protect parties from bad faith claims. It can also erase good faith promises that didn't survive the drafting process. It can take a handshake and turn it into nothing. It can make Marcus Venn's assurances legally irrelevant. It can transform "I give you my word" into "show me where it says that in the contract." Thomas signed on November 19th. Marcus signed 2 days later. The wire transfer hit Harborline's account on November 27th, $42 million. The partnership was official. Thomas celebrated with his team. They'd done it. They'd secured the capital and the access they needed to compete at a new level. For 6 months, everything seemed fine. Act 2, the betrayal, the silence. February rolled around. Thomas Harborline had been patient. The investment was in. The board seats were filled. Northbridge representatives attended monthly meetings. They reviewed financials. They approved budgets. Everything was professional, cooperative. But the West Coast freight hadn't materialized. Thomas reached out to Marcus Venn, just checking in. When could they expect to start seeing those distribution opportunities they'd discussed? Marcus was friendly. These things take time. They were still evaluating logistics, coordinating with their West Coast operations. Soon, March, nothing. Thomas called again. This time Marcus was less available. His assistant said he was traveling, in meetings. She'd pass along the message. A week later, Thomas received an email from a Northbridge operations director he'd never met, thanking him for his inquiry, explaining that Northbridge regularly evaluated vendor relationships based on competitive bids. Harborline was welcome to submit proposals like any other logistics company. Submit proposals like any other company. Thomas read the email 3 times. This wasn't what they'd agreed to. This wasn't preferred vendor status. This was being treated like a stranger. April. Thomas attended a board meeting. He raised the issue directly. 2 Northbridge representatives were present. One of them, a woman named Jennifer Moss, responded calmly. Northbridge was committed to working with Harborline where it made operational sense. They just needed to ensure competitive pricing, market rates, standard procedure. Thomas felt his frustration rising. When we negotiated this deal, Marcus promised that Harborline would have first right of refusal on West Coast freight. That was a material term. That's why we accepted the equity structure we did. Jennifer's expression didn't change. I understand there were preliminary discussions, but the agreement we signed outlines the actual terms of our relationship. We're operating consistent with that agreement. Thomas called Dana Brooks that afternoon. He was angry, felt betrayed. Marcus had looked him in the eye and given his word. Now Northbridge was acting like those conversations never happened. Dana listened. She'd been afraid of this. She pulled out the contract, read Section 8 again, the discretionary language. Then she flipped to page 17, the integration clause. She explained it to Thomas carefully. The merger clause meant that legally, those earlier promises might not matter. The contract was the entire agreement. If the West Coast commitment wasn't explicitly written in, Northbridge could argue they never agreed to it. Thomas was silent for a long moment. Then, "But they did agree to it," Marcus promised. "I have witnesses. We have emails from the negotiation." Dana felt the weight of what was coming. "We can try to prove that, but it's going to be hard. Integration clauses exist specifically to prevent this kind of claim. So they can just lie, make promises, get us to sign, and then walk away." Dana chose her words carefully. They'd argue they're not lying. They'd argue that whatever was discussed in preliminary negotiations, the contract is what both parties ultimately agreed to. And the contract gives them discretion. The collapse may brought clarity, the kind nobody wants. Northbridge sent a formal letter. It was polite, professional, corporate language designed to deliver bad news with a smile. They thanked Harborline for their interest in pursuing distribution opportunities. Unfortunately, after a thorough review, Northbridge had decided to continue with their existing West Coast logistics partners. The current vendor relationships were performing well. No changes were planned. Translation: you're not getting the business. The promise is dead. Thomas sat in his office and did the math. The $42 million investment had been structured around future growth. Growth that was supposed to come from West Coast access. Without that revenue, the expansion they'd planned wasn't viable. They'd taken on debt, hired staff, opened a new facility in Ohio specifically to handle the increased volume they'd been promised. All based on Marcus Venn's word. And now that word meant nothing. Thomas made a decision. He wasn't going to accept this. Northbridge had negotiated in bad faith. They'd made promises to induce Harborline into accepting less favorable equity terms. They'd committed fraud or misrepresentation or something. There had to be a legal remedy. He called Dana. "We're suing them." Dana had expected this. She'd already started preliminary research. The legal theories were complicated. Promissory estoppel, fraudulent inducement, negligent misrepresentation, but every theory ran into the same wall, that integration clause on page 17. She explained the challenges. Proving fraud would require showing that Northbridge never intended to honor their promises. That's a high bar. Misrepresentation claims get difficult when the parties signed a contract saying the contract is the entire agreement. Thomas didn't care about the obstacles. "They lied to us. They got us to sign a deal based on false promises. There has to be accountability for that." Dana nodded. She agreed morally, even if the law was going to make this complicated. "All right, let's build the case. I'm going to need everything, every email, every note from every meeting, every witness who heard Marcus make those promises. We're going to show that Northbridge induced you into this contract through misrepresentation. The evidence." Building a case like this is detective work. You're reconstructing conversations that happened months ago. You're finding the digital breadcrumbs that prove what was said, what was promised, what was understood. Dana dove in. The emails were the strongest evidence. In June, during early negotiations, there were multiple exchanges referencing West Coast access. Marcus Venn had sent Thomas an email with the subject line, "Partnership Opportunities." In it, he wrote, "As we discussed, Northbridge's West Coast distribution network will be a key benefit of this partnership. We move significant freight through our facilities in Los Angeles, Oakland, and Seattle. Harborline will be positioned as our preferred logistics partner for these operations. Preferred logistics partner." In writing, from Marcus Venn himself. Dana highlighted the email. This was gold, but then she kept reading the thread. 3 emails later, Thomas had responded, "Just to confirm, we'll have guaranteed access to route at least 25% of your West Coast freight." Marcus's reply was shorter. "Let's nail down the specifics as we finalize the agreement." The intent is absolutely to make this a meaningful partnership. The intent, not a commitment, not a guarantee. The intent. Dana felt her case getting weaker. Defense counsel would argue that this email showed Marcus was deferring to the final contract, that he was being careful not to make binding promises outside the formal agreement. She kept digging. There were more emails. A chain in August where Dana herself had asked Richard Wolff to include explicit West Coast commitments. Richard's response referenced preliminary discussions but emphasized that the contract would contain the binding terms. Another email in September where Dana had pressed again. Richard had written, "All material terms are reflected in the current draft. We believe the parties understand the scope of the operational relationship." Dana made notes. These emails cut both ways. They showed that Harborline had pushed for explicit language and Northbridge had resisted. But they also showed that both sides knew the contract was going to be the final word. That integration clause wasn't an accident. Both legal teams had seen it, had accepted it. Thomas provided witness statements. 3 Harborline executives who'd been present at various meetings with Northbridge representatives. All of them confirmed that Marcus Venn had repeatedly referenced West Coast access as a key component of the deal. One of them, Harborline's CFO, remembered Marcus saying in a July meeting, "You're worried about growth? Don't be. We're going to send you more business than you can handle." More business than you can handle. That sounded like a promise, but it was oral, preliminary, subject to that integration clause. Dana also found something interesting in the document metadata. The contract had gone through 12 drafts. She requested all of them in discovery. In Draft 7, there had been a section titled Preferred Vendor Status that outlined specific commitments for West Coast freight. That section had been deleted in Draft 8. Who deleted it? The metadata showed the change came from Northbridge's legal team. Richard Wolff's fingerprints were all over it. This mattered. It showed that at one point the commitment had been written into the contract. Northbridge had removed it. That suggested intentionality, an effort to eliminate a binding obligation while keeping the verbal promise alive long enough to close the deal. But here's the problem. Contracts get negotiated. Terms get added and removed. The fact that something appeared in an early draft doesn't mean the final version has to include it. Courts understand that negotiation is a process. If Harborline didn't like Draft 8, they could have walked away. They didn't. They signed. Dana kept searching for the angle, the legal theory that would break through. She researched case law on integration clauses. She found dozens of cases, hundreds. The message was consistent. When parties sign a contract with a merger clause, prior promises and negotiations are generally inadmissible. The contract is the agreement, period. But there were exceptions, narrow ones. Courts would sometimes look beyond the contract if there was fraud, if one party deliberately misrepresented material facts to induce the other party to sign, or if the contract was ambiguous. If the written terms were unclear, courts might consider external evidence to interpret what the parties meant. Dana read Section 8 of the Harborline Northbridge contract again. Northbridge may, at its discretion, utilize Harborline services for distribution and logistics operations where operationally feasible and commercially reasonable. Was that ambiguous? Maybe. It didn't say Northbridge wouldn't use Harborline services, it just made it discretionary. But discretion still implies some obligation to consider, to evaluate in good faith. Perhaps Dana could argue that operationally feasible and commercially reasonable created an obligation that Northbridge violated. It was thin, but it was something. She filed the complaint in June, Harborline Logistics versus Northbridge Holdings, United States District Court, Southern District of New York. The claims were carefully crafted: breach of contract, fraudulent inducement, negligent misrepresentation, breach of implied covenant of good faith and fair dealing. The complaint was 83 pages. It told the story of Marcus Venn's promises, the emails, the negotiations, the deleted contract language, the eventual betrayal. The damages were calculated conservatively, Lost profits from the West Coast Business Harbor Line should have received $38 million over 5 years. Costs incurred in reliance on Northbridge's promises, $12 million for facility expansion and staffing. Harm to business relationships and reputation, $5 million. Total, $55 million. Northbridge's response was swift and predictable, a motion to dismiss. Their argument was simple. The integration clause barred Harborline's claims. Whatever was said before the contract was signed didn't matter. The contract was clear. Northbridge had discretion. They exercised that discretion. End of story. The motion was filed by Victor Lang. Dana knew him by reputation. Senior partner at a white shoe Manhattan firm. Decades of experience. The kind of attorney who didn't just argue the law, but shaped it. His briefs were surgical, his logic airtight, and his motion to dismiss hit every note perfectly. Dana filed her opposition. She argued fraud exception. She argued ambiguity. She argued that the implied covenant of good faith and fair dealing meant Northbridge couldn't simply ignore Harborline after taking their money. She cited cases. She distinguished precedents. She wrote 112 pages explaining why this case deserved to proceed to trial. Judge Samuel Keene read both submissions. He scheduled oral arguments for September. Act 3. The hearing the arguments. Federal courtrooms in the Southern District of New York have a certain gravity, high ceilings, dark wood, the weight of history. Judge Samuel Keene's courtroom was no different. He'd been on the bench for 16 years. Reputation for fairness. Known for asking tough questions, he didn't suffer sloppy lawyering. September 14th, morning light filtered through tall windows. Dana Brooks sat at the plaintiff's table, Thomas Harborline beside her. Across the aisle, Victor Lang and a team of 3 associates. Marcus Venn wasn't present. Northbridge had sent a junior executive to observe. Message received. They didn't think this case was worth senior management's time. Judge Keene entered. Everyone rose. He settled into his chair and looked at the docket. We're here on defendant's motion to dismiss. Mr. Lang, you may proceed. Victor Lang stood. He didn't need notes. He'd argued motions like this 100 times. Your Honor, this case should not proceed past this motion for a simple reason. The parties signed a contract. That contract contains an integration clause explicitly stating that prior negotiations and representations are superseded by the written agreement. Plaintiff wants this court to ignore that clause and rewrite the deal based on preliminary discussions. We respectfully submit that doing so would undermine the most basic principles of contract law. He walked through the elements. The integration clause was clear, unambiguous. Both parties were represented by sophisticated counsel. Both parties understood what they were signing. The complaint alleged that verbal promises were made during negotiations. Perhaps they were. But those promises didn't make it into the final contract. That's not fraud. That's negotiation. Judge Keene leaned forward. Counsel, what about the plaintiff's fraud allegations? They claim your client deliberately misrepresented its intentions to induce them to sign. Victor didn't hesitate. Your Honor, the fraud claim fails for several reasons. First, any alleged misrepresentation was about future conduct, not present fact. Promises about what might happen in the future are not actionable fraud. Second, even if we accept plaintiff's version of events, my client's representatives expressed an intent to work with Harborline, which is exactly what the contract allows for. We have discretion to utilize their services where operationally feasible. We've exercised that discretion. Third, and most importantly, plaintiff cannot rely on pre-contractual statements when they signed a contract explicitly disclaiming those statements. It was a strong argument. Dana felt it, but she'd prepared for this. Judge Keene turned to her. Ms. Brooks, response? Dana stood. Your Honor, defendant wants to hide behind the integration clause to excuse blatant misrepresentation. This isn't a case of negotiation positions changing over time. This is a case of deliberate fraud. Mr. Venn looked my client in the eye and promised West Coast access. He put it in writing in emails. He reaffirmed it even after the contract was signed. Northbridge induced Harbourline to accept less favourable equity terms by promising operational benefits they never intended to deliver. She pulled out the emails, quoted Marcus Venn's language. "Preferred logistics partner. Key benefit of this partnership. We're going to send you more business than you can handle." These weren't casual comments, Your Honour. These were material inducements that shaped the deal. Judge Keene looked sceptical. But Ms. Brooks, your client's own attorney, meaning you, negotiated this contract. You saw the integration clause. You saw that the West Coast commitment wasn't explicitly included. Why didn't you walk away from the deal? This was the question Dana had been dreading. It was the weakness in her case. The moment where theory meets reality. Your Honour, we trusted the relationship. Mr. Venn personally assured my client, after the draft was finalized, that the commitment remained intact. We relied on that representation. The law recognizes that sophisticated parties can still be victims of fraud when one party deliberately misrepresents material facts. Victor Lang jumped back in. Your Honour, this proves our point. Plaintiff's counsel admits they saw the contract, admits they understood the terms, admits they chose to sign anyway. They can't now claim fraud because the relationship didn't develop as they hoped. That's buyer's remorse, not fraud. The hearing went on for 90 minutes. Back and forth, case law, precedents. Judge Keene asked pointed questions. He wanted to understand the timeline, who said what and when. Whether there was evidence that Northbridge never intended to honor the West Coast commitment or simply changed their mind later. That distinction mattered. Fraud requires intent to deceive at the time the statement was made. If Northbridge genuinely meant to work with Harbourline but later decided against it for legitimate business reasons, that's not fraud. That's discretion. Dana presented her best evidence. The deleted contract language in Draft 7, the metadata showing Northbridge removed the preferred vendor status section, the timeline showing that Marcus Venn reaffirmed the commitment even after that deletion. She argued this demonstrated a pattern of deliberately misleading Harbourline while systematically removing any binding obligation from the written contract. Victor countered that negotiation always involves give and take. Draft 7 was just that. A draft. Harbourline's counsel reviewed every subsequent version. They had every opportunity to insist the language be reinstated. They didn't. Instead, they signed a contract giving Northbridge discretion. Courts don't rewrite deals just because one party later regrets the terms. Finally, Judge Keene leaned back. I'll take this under advisement. Counsel should expect a ruling within 30 days. The ruling. 27 days later, the ruling came. 18 pages. Judge Keene had clearly wrestled with the issues. The opinion was thorough, thoughtful, and devastating for Harbourline. He started with the basic principle. Integration clauses are enforceable. They serve important purposes. They create certainty. They prevent parties from endlessly relitigating what might have been said during negotiations. When sophisticated parties represented by counsel sign a contract with a merger clause, courts presume they understood what they were doing. Then he addressed the fraud claim. He acknowledged the emails, the statements from Marcus Venn, the deleted contract language. He found that these facts, taken together, were troubling. They suggested that Northbridge may have deliberately maintained verbal assurances while removing written commitments. But did that rise to the level of actionable fraud? Judge Keene concluded it did not. The emails showed intent, not misrepresentation of fact. The deleted contract language showed negotiation, not deception. And critically, Harbourline's own counsel had reviewed the final contract and advised the client to sign. That demonstrated that Harbourline, with full knowledge of the written terms, chose to rely on the relationship rather than insist on explicit contractual protections. That was a business decision, not fraud. As for the breach of contract claim, Judge Keene found that Section 8 gave Northbridge broad discretion. The language was clear, may, at its discretion. That meant Northbridge could choose whether to use Harbourline services. They chose not to. That wasn't a breach. That was the contract working exactly as written. The implied covenant of good faith and fair dealing claim also failed. Judge Keene noted that New York law does recognize such a covenant, but it doesn't create obligations that contradict the express terms of a contract. If the contract gives a party discretion, the implied covenant doesn't eliminate that discretion. Northbridge was free to exercise its business judgment. The motion to dismiss was granted. On all counts, the case was over. Dana called Thomas with the news. He was quiet. She could hear the defeat in his silence. Then, "So that's it? They just get away with it?" Dana felt the weight of failure. "We can appeal, but I have to be honest with you. The judge's reasoning is sound. The law is on their side. That integration clause is exactly what it was designed to be. A shield." Thomas was bitter. "Then what's the point of a handshake? What's the point of someone giving you their word if the law says it means nothing?" Dana didn't have a good answer, because he was right. The law had chosen certainty over justice, text over trust, and it felt wrong. But then something unexpected happened. Act 4. The reversal, the discovery. Dana didn't give up. She couldn't. Even with the dismissal, she had 30 days to appeal. She spent them searching. There had to be an angle, some legal principle that could breathe life back into this case. She read everything: contract law treatises, New York case law going back decades, federal opinions interpreting integration clauses. She was looking for an exception, a crack in the wall. Late one night, surrounded by stacks of law books and empty coffee cups, she found something. A case from 1978, obscure, rarely cited. It involved a different context entirely, a dispute over a commercial lease. But buried in the opinion was language about integration clauses and a concept called subsequent oral modification. The principle was simple but powerful. Even when a contract contains an integration clause saying it can only be modified in writing, some courts have found that parties can still orally modify the agreement if they both clearly intend to do so and act on that modification. The logic is that if an integration clause can be written into a contract by the parties, it can also be waived by the parties through their subsequent conduct. Dana read the case 3 times. Then she started tracing its history. How many times had it been cited? Had any court rejected its reasoning? She found a handful of citations. Most were neutral. But 2 cases, one from 1986 and one from 2009, had applied the principle. Both involved situations where parties signed contracts with merger clauses, but then verbally agreed to change key terms. Both courts held that the subsequent oral modification could be enforced despite the integration clause. The key was proving that both parties clearly understood they were modifying the contract and acted in reliance on that modification. It couldn't be a casual conversation. It had to be deliberate, intentional. And there had to be evidence that both sides treated the oral modification as binding. Dana's mind raced. After the contract was signed, Marcus Venn had called Thomas. He'd reassured him that the West Coast commitment was still in place. That call happened in late November, days after the contract was executed. Could that constitute a subsequent oral modification? Could that conversation, coming after the integration clause took effect, create a new enforceable promise? She checked the precedents again. The 1978 case emphasized that the modification had to be clear. The parties had to demonstrate through words and actions that they were changing the deal. In that case, a landlord and tenant had signed a lease with a merger clause, but then verbally agreed that the tenant could sublet the space. The landlord later tried to enforce the no subletting provision in the written lease. The court held that the subsequent oral agreement to allow subletting was enforceable because both parties clearly understood they were modifying the contract, and the tenant had relied on that modification by finding a subtenant. Dana pulled the phone records. Thomas had mentioned that Marcus called him. Could they prove that call happened? Could they prove what was said? Thomas would testify. But would that be enough? She kept digging. Then she found something else. In December, a month after the contract was signed, Northbridge had sent Harbourline a questionnaire. It asked for information about Harbourline's operational capacity, equipment, insurance coverage, and service areas. The questionnaire specifically referenced anticipated distribution opportunities in West Coast markets. Dana stared at the document. This wasn't just Marcus Venn making verbal promises. This was Northbridge, through its operations team, acting as if the West Coast commitment was real. They were asking Harbourline for information necessary to execute on that commitment. They were preparing to move forward with the partnership as promised. And Harbourline had responded. They'd filled out the questionnaire, provided detailed information about their capacity to handle West Coast freight. They'd done so in reliance on Northbridge's representations. This was the proof Dana needed. Both parties, after signing the contract, had acted as if the West Coast commitment existed. Northbridge had sent the questionnaire. Harbourline had responded. That demonstrated mutual understanding that the written contract's discretionary language didn't capture the full deal. They were modifying it through their conduct. Dana drafted an emergency motion for reconsideration. She cited the 1978 case. She explained the subsequent oral modification doctrine. She attached the phone records showing Marcus Venn's call to Thomas. She attached the December questionnaire. She argued that even if the integration clause barred pre-contractual promises, it didn't bar post-contractual modifications that both parties clearly understood and relied upon. It was a long shot. Motions for reconsideration rarely succeed. Judges don't like revisiting their own rulings. But Dana filed it anyway. She included a detailed memorandum of law, 57 pages, every citation checked, every argument polished. Victor Lang filed an opposition, of course. He argued that the subsequent oral modification doctrine was limited to cases where both parties explicitly agreed they were changing the contract. A phone call and a questionnaire weren't enough. There was no writing, no clear manifestation of intent to modify, and even if there was, the contract itself specifically required written modifications. That clause wasn't just about integration, it was about how future changes had to be documented. Judge Keene scheduled another hearing. The expert, Dana, knew she needed more than legal argument. She needed someone who could explain to the court why this doctrine mattered, why it made sense, why ignoring post-contractual conduct would create perverse incentives for parties to sign contracts with restrictive language, but then operate under verbal understandings. She reached out to Professor Carmen Soto, Cornell Law School, nationally recognized expert on contract law, author of 3 textbooks and dozens of law review articles. Professor Soto had written extensively about integration clauses and the tension between written formalism and commercial reality. Dana sent her the case file, asked if she'd be willing to testify. Professor Soto agreed. She found the case fascinating. A perfect example of why bright-line rules about integration clauses sometimes fail to capture what parties actually intend. She prepared a detailed expert report. The report was 38 pages. It walked through the history of integration clauses, explained their purpose to prevent the uncertainty and litigation that arise when parties dispute what was said during negotiations. But it also explained their limitations. Integration clauses work when the written contract accurately reflects the parties' complete agreement. They become problematic when parties sign a written agreement but then immediately modify it through their subsequent actions. Professor Soto cited research showing that sophisticated commercial parties often operate this way. They sign formal contracts to satisfy legal departments and create a baseline framework. But then they adapt the relationship based on changing circumstances, market conditions, and ongoing negotiations. They do this verbally, through emails, through conduct. The law needs to recognize this reality, or integration clauses become tools for bad faith parties to escape obligations they clearly undertook. The key question, Professor Soto argued, was whether both parties understood they were creating a new obligation after the contract was signed. In this case, the evidence suggested they did. Northbridge sent the questionnaire. Harbourline responded. Both parties acted as if the West Coast commitment was binding, despite the discretionary language in Section 8. Dana filed the expert report with her motion for reconsideration. Victor Lang filed his own expert, a professor from Columbia who took the opposite view. His opinion argued that allowing oral modifications to override written integration clauses would create chaos. Parties need certainty. They need to know that when they sign a contract stating it can only be modified in writing, that provision will be enforced. Otherwise, every contract dispute becomes a battle over who said what after the fact. Both experts had valid points. This wasn't a case where one side was clearly right and the other clearly wrong. This was a case about competing values, flexibility versus certainty, equity versus predictability, substance versus form. Judge Keene read everything. The motion for reconsideration, the expert reports, the opposition. He scheduled oral arguments for late October. The clause. The second hearing had a different energy. The first time it had felt like a routine dismissal motion. This time, everyone sensed something bigger was at stake. The courtroom was more crowded. Several law professors sat in the gallery, curious about how Judge Keene would handle the subsequent oral modification issue. A legal blogger was live tweeting the proceedings. Dana stood to argue first. She got straight to the point. Your Honor, we're not asking this court to ignore the integration clause. We're asking the court to recognize what happened after the contract was signed. Northbridge sent my client a questionnaire specifically referencing West Coast distribution opportunities. That questionnaire asked for operational information that would only be relevant if Northbridge intended to use Harbourline's services. My client responded in good faith. Both parties acted as if the commitment was real. Judge Keene interrupted. But Ms. Brooks, the contract says modifications must be in writing. Even if I accept your argument about subsequent conduct, doesn't that clause bar oral modifications? This was the moment. Dana had prepared for this exact question. Your Honor, the case law draws a distinction between what parties say the rules are and what they actually do. When both parties, through their conduct, demonstrate that they're modifying an agreement, courts have held that they've waived the written modification requirement. The leading case is Morrison v. Hartley from 1978. That case involved a similar provision requiring written modification. The court held that the parties, through their clear and unequivocal conduct, had waived that requirement. She handed up copies of Morrison v. Hartley and two other cases following its reasoning. Judge Keene flipped through them. He looked interested but cautious. Victor Lang stood for rebuttal. Your Honor, plaintiff is asking this court to create uncertainty where the parties created clarity. They signed a contract. That contract has an integration clause. It has a written modification clause. Both provisions exist for a reason, to prevent exactly this kind of dispute. If we allow parties to claim verbal modifications based on ambiguous conduct, every contract becomes a trial about who remembers what conversation. He had a point. Judge Keene nodded slowly. Mr. Lang, what about the questionnaire? That seems like more than ambiguous conduct. Northbridge specifically asked about West Coast capacity after the contract was signed. Victor didn't miss a beat. Your Honor, that questionnaire was part of ordinary due diligence. Northbridge was evaluating potential vendors. The fact that they asked questions doesn't mean they committed to anything. The contract gives us discretion. We were exercising that discretion by gathering information. Dana stood again. Your Honor, may I respond to that point? Judge Keene nodded. If Northbridge was merely evaluating Harbourline as one of many potential vendors, why did the questionnaire specifically reference anticipated distribution opportunities? Not potential opportunities, not possible opportunities. Anticipated. That word reflects an expectation, a commitment. The hearing went on for 2 hours. Professor Soto testified. She explained the policy considerations. The importance of allowing parties to modify their agreements through conduct when that's what they clearly intended. She walked through the Morrison case in detail. The judge in that case had written, "To hold otherwise would be to elevate form over substance and permit a party to escape obligations it clearly undertook by hiding behind technicalities it subsequently chose to ignore." Victor's expert testified in rebuttal. He emphasized the need for predictability, the dangers of allowing oral modifications, the importance of enforcing contracts as written. Finally, Judge Keene called for a recess. "I need time to consider this. The motion for reconsideration is taken under advisement." 3 weeks passed. Then the opinion arrived. The decision Judge Keene had changed his mind. The opinion was remarkable. 23 pages that walked through his reasoning step by step. He started by acknowledging his initial ruling. He'd been correct, he wrote, that integration clauses are generally enforceable and that pre-contractual promises typically don't survive them. But this case, he now believed, presented a different question. Not whether pre-contractual promises could override the written agreement, but whether post-contractual conduct could modify it. And on that question, the law was more nuanced than he'd initially appreciated. He quoted Morrison versus Hartley extensively. That case, he noted, stood for the proposition that parties can waive written modification requirements through their subsequent conduct. The key was whether both parties clearly understood they were creating a new obligation and acted in reliance on it. Here, Judge Keene found that they had. The phone call from Marcus Venn to Thomas Haberlein, coming days after the contract was signed, was not mere reassurance. It was a representation that the West Coast commitment remained in force. More importantly, the questionnaire sent by Northbridge in December demonstrated that Northbridge itself was treating the commitment as real. They weren't asking general questions. They were asking specifically about Haberlein's ability to handle anticipated West Coast distribution. Judge Keene wrote, "When a party represents to its counterparty that a certain commitment exists and then takes affirmative steps consistent with that commitment by requesting detailed operational information, it cannot later claim that no such obligation ever arose. To permit otherwise would be to sanction a form of commercial bad faith that our contract law should not countenance." He found that Haberlein had reasonably relied on Northbridge's post-contractual representations. They'd filled out the questionnaire. They'd maintained capacity. They'd foregone other opportunities in anticipation of the Northbridge business. That reliance was detrimental and foreseeable. Most critically, Judge Keene found that the integration clause, while enforceable as to pre-contractual negotiations, did not bar consideration of post-contractual modifications. The Morrison doctrine allowed courts to find waiver of written modification requirements when the party's conduct clearly demonstrated an intent to modify. That's what happened here. The motion to dismiss was vacated. The case would proceed to discovery and, if necessary, trial. Northbridge would have to defend not just the written contract, but their conduct after signing it. Dana read the opinion 3 times. She could barely believe it. A doctrine from a 1978 case, rarely cited, had just reversed a dismissal in an $83 million dispute. 17 words in an integration clause still mattered, but they didn't end the case. The subsequent oral modification doctrine created a path forward. Thomas was elated. "So we're back in?" Dana smiled. "We're back in. Now we have to prove what Northbridge promised, and that they never intended to honor it." Victor Lang immediately filed a notice of appeal. He argued that Judge Keene had misapplied Morrison and created dangerous precedent. The case was heading to the Second Circuit Court of Appeals, but that would take months. In the meantime, discovery would proceed. The email's discovery in complex commercial litigation is brutal. Requests for documents, interrogatories, depositions. Every email, every text, every memo becomes potential evidence. Dana issued subpoenas for all communications between Northbridge executives regarding Haberlein. She wanted to see what they were saying internally about the West Coast commitment. What came back was explosive. In January, 2 months after the contract was signed, and 1 month after the questionnaire was sent, Marcus Venn had emailed Jennifer Moss, the Northbridge Operations Director. The subject line was Harbour Line Situation. The body of the email was short. We need to slow play the West Coast thing. I know we discussed giving them preferred access, but the board is concerned about locking into vendor commitments. Let's keep them hopeful, but delay any actual routing until we see how the investment performs. Dana read it again. Slow play. Keep them hopeful. This was evidence of deliberate deception. Marcus Venn knew Northbridge had created an expectation. He was consciously managing Harbour Line to prevent them from realizing that expectation wouldn't be fulfilled. There were more emails. In February, after Thomas had started asking about the West Coast freight, Jennifer Moss wrote to Marcus, Harbour Line CEO is getting insistent about distribution opportunities. How should I handle? Marcus's response, be polite but non-committal. We never made guarantees. The contract gives us discretion. Never made guarantees, but they had. The questionnaire, the phone calls, the representations, all of it documented. And now, internal emails showing that Northbridge executives knew they'd created expectations and were deliberately managing those expectations to avoid fulfilling them. Dana took Marcus Venn's deposition in March. He was polished, prepared. Victor Lang had coached him well. When asked about the West Coast commitment, Marcus acknowledged that he'd discussed it with Thomas during negotiations, but he characterized those discussions as preliminary, exploratory, not binding. Dana showed him the questionnaire. Mr. Venn, this document refers to anticipated distribution opportunities in West Coast markets. That's your company's document, sent after the contract was signed. What did you mean by anticipated? Marcus didn't flinch. We were exploring whether a partnership with Harbour Line made sense for our West Coast operations. Anticipated means we thought it might happen, not that it would definitely happen. Dana pulled out the January email. The slow play email. Mr. Venn, you wrote here that you needed to keep them hopeful about West Coast access. Why would you need to keep them hopeful if you hadn't created an expectation? Marcus shifted slightly. That language was imprecise. What I meant was that we wanted to maintain a good working relationship while we evaluated the partnership. The deposition went on for 6 hours. Marcus stuck to his story. He'd never made guarantees. The contract controlled. Harbour Line misunderstood the nature of the relationship, but the emails told a different story. They showed knowledge, intent, deliberate management of expectations. Dana deposed Jennifer Moss. She was less polished. Under questioning, she admitted that after receiving the questionnaire response from Harbour Line, she'd prepared a draft routing plan for West Coast freight. She'd calculated costs, compared Harbour Line's rates to existing vendors. She'd done the work you do when you're planning to use someone's services, not when you're merely evaluating hypothetical possibilities. What happened to that routing plan? Dana asked. Jennifer hesitated. It was never implemented. Why not? Marcus said we were putting West Coast partnership opportunities on hold. When did he say that? Early January. Before or after you sent the questionnaire to Harbour Line? Jennifer thought carefully. After. This was the timeline Dana needed. Northbridge sent the questionnaire in December, creating the impression they were moving forward. Jennifer prepared a routing plan. Then in early January, Marcus decided to slow play the commitment. By February, they were stonewalling Thomas. The pattern was clear. Induce reliance, then renege. The settlement talks by April. Both sides understood where this was headed. Trial would be expensive, risky for both parties. Northbridge faced the possibility of a jury hearing about Marcus Venn's slow play email. That wouldn't look good. But Harbour Line also faced risk. Even with the subsequent oral modification doctrine, they still had to prove damages. They still had to show that Northbridge's promises, if enforced, would have resulted in the profits they claimed. Victor Lang reached out to Dana. Would Harbourline consider settlement discussions? Dana consulted with Thomas. He wanted his day in court. He wanted a jury to hear what Northbridge had done, but he also understood the risk. A trial could take 2 years from now, with appeals adding another 2 years. Meanwhile, Harbourline needed to focus on running its business, not fighting litigation. They agreed to mediation. A retired federal judge, Harold Martinez, served as mediator. Both sides submitted confidential mediation statements outlining their positions. The mediation took place over 2 days in a neutral conference facility in Manhattan. Victor opened with Northbridge's position. The contract gave them discretion. They'd exercise that discretion. They were willing to consider a modest settlement to avoid litigation costs, but they maintained they'd done nothing wrong. He offered $2 million. Take it or leave it. Dana was offended. $2 million didn't even cover Harbourline's costs in relying on Northbridge's promises. She presented the emails, the timeline, the evidence of bad faith. She demanded $40 million, compensation for the lost West Coast business and the costs Harbourline had incurred. The mediator shuttled between rooms. He told Northbridge their emails were a problem. He told Harbourline that proving $40 million in damages would be difficult. He pushed both sides toward reality. By the end of day 1, Northbridge was at $8 million. Harbourline was at $32 million. Still a canyon between them. The mediator suggested they sleep on it, think about what trial would really mean, the costs, the uncertainty, the years of their lives consumed by litigation. Day 2 started tense. Victor made a move, $15 million, final offer. Dana countered with $28 million. The mediator worked the numbers. What could Harbourline actually prove in damages? What exposure did Northbridge really face? He came back with a proposal, $22 million, structured as a combination of cash payment and guaranteed freight contracts over 3 years. Dana presented it to Thomas. It wasn't full justice, but it was real money, and it included the operational relationship they'd wanted from the beginning. Thomas thought about the years ahead, the stress of trial, the risk that a jury might not see it their way despite the emails. He looked at Dana. What do you recommend? Dana was honest. I think we can win at trial, but I also think this is a fair offer. It compensates you for most of what you lost. It gives you the West Coast access you wanted, and it lets you move forward with your business instead of being consumed by this case. Thomas signed the settlement agreement that evening. $22 million. Northbridge would pay $12 million in cash and guarantee Harbourline a minimum of $10 million in freight business over 3 years at competitive rates. Northbridge admitted no wrongdoing, but agreed to the terms as a resolution of the dispute. The case was dismissed with prejudice. Both parties signed confidentiality agreements preventing them from discussing the settlement terms. But the legal principle established by Judge Keene's reconsideration opinion remained. The subsequent oral modification doctrine had saved Harbourline's case. Dabei des epilogue, the legacy, the precedent. Judge Keene's opinion didn't stay obscure. Within 6 months, 3 other federal courts cited it, 2 district courts in New York and 1 in Delaware. All 3 involved situations where parties had signed contracts with integration clauses, but then allegedly modified those contracts through subsequent conduct. Judge Keene's reasoning, his reliance on the Morrison doctrine, his careful analysis of when post-contractual behavior can override written terms, it all became precedent that other judges could rely on. Law professors started teaching the case. It appeared in contract law supplements for second-year law students. Professor Soto wrote a law review article analyzing the opinion and its implications for modern commercial practice. She argued that Judge Keene had gotten it right, that integration clauses serve important purposes, but shouldn't be treated as absolute bars to considering how parties actually conducted themselves after signing. Other scholars disagreed. A professor at Yale published a response arguing that Judge Keene's opinion created dangerous uncertainty. If parties can't rely on integration clauses to prevent disputes about subsequent oral modifications, what protection do they have? Every contract becomes potentially subject to renegotiation through informal conversations and ambiguous conduct. That undermines the whole point of written agreements. The debate continues in legal circles. But for practitioners, the lesson was clear. Integration clauses matter, but they're not invincible. Courts will look at what happened after a contract was signed. They'll consider whether parties, through their actions, demonstrated an intent to modify their agreement. And if the evidence shows bad faith, shows that one party deliberately created expectations and then refused to honor them, courts have tools to provide a remedy. The lesson. What does this case teach us? On one level, it's about contract drafting. If you're negotiating a deal and verbal promises are being made that matter to you, insist they go in the written contract. Don't rely on handshakes. Don't trust assurances that we'll work it out. Get it in writing. Make it explicit. That's the safe approach. But this case also reveals the limitations of that advice, because sometimes you do get it in writing, or try to, and the other side removes it in later drafts. Sometimes you're negotiating with a party that has more leverage, and you have to choose between accepting imperfect terms or walking away from a deal you need. Thomas Harberline faced that choice. He chose to trust Marcus Venn's word, and legally, that nearly destroyed him. The subsequent oral modification doctrine saved him, but it's a narrow doctrine. It requires proof, clear evidence that both parties understood they were modifying the contract. In this case, the questionnaire provided that evidence. The internal emails provided it. But if Northbridge had been slightly more careful, if they'd managed to string Harberline along without leaving such a clear paper trail, the outcome might have been different. There's a moral question buried in this case too. Should the law prioritize what parties wrote or what they intended? Should it focus on the formal contract or the actual relationship? Judge Keene struggled with this. His first opinion prioritized the written contract. The integration clause was clear. It meant what it said. But his second opinion acknowledged that human relationships, even commercial ones, are more complex than legal documents. People make promises. They create expectations. They operate based on trust and understanding, not just contract clauses. When one party exploits that gap between formal terms and actual conduct, when they hide behind integration clauses while deliberately misleading their counterparty, the law has to respond. Not by ignoring written contracts, but by recognizing that contracts exist within relationships, and relationships involve ongoing communication and adaptation. The aftermath. Thomas Harberline rebuilt his company. The settlement money helped. The guaranteed freight contracts from Northbridge provided the West Coast access he'd originally sought, though under different terms than he'd hoped. Harberline Logistics grew. Within 3 years, they'd expanded their West Coast operations beyond Northbridge to include several other major clients. The company eventually went public in a modest IPO. Thomas stepped back from day-to-day operations. He'd earned the rest. He never spoke publicly about the Northbridge case, bound by the confidentiality agreement, but privately he told friends and family that it was the hardest experience of his professional life. Not because of the legal battle, but because it forced him to confront an uncomfortable truth. In business, your word isn't always your bond. Contracts matter, leverage matters, and sometimes people you trust will look you in the eye and lie. Dana Brooks continued practicing law. The Harberline case became one of her career highlights. She'd taken a dismissed case, found an obscure legal doctrine, and reversed the outcome. That's what good lawyers do. They don't accept defeat. They keep searching for angles, for precedents, for arguments that might work. She used Judge Keene's opinion in several subsequent cases, always pointing to the principle that courts will look beyond integration clauses when justice requires it. Victor Lang also moved on. He didn't view the case as a loss exactly. His client paid to settle, but avoided a trial that could have been far more damaging. The internal emails would have looked bad to a jury. Marcus Venn's testimony had been shaky in places. Settlement was the smart business decision. He continued representing corporate clients in complex commercial disputes, always advising them to be careful about what they put in writing after a contract is signed. Because, as Harborline showed, post-contractual communications can come back to haunt you. Northbridge Holdings continued operating. Marcus Venn quietly left the company 6 months after the settlement. The official story was that he was pursuing other opportunities. The real story, whispered in private equity circles, was that the board had lost confidence in him after the Harborline debacle. He'd cost them $22 million and created legal exposure that could have been far worse. He landed at a smaller firm, still in private equity, but with less authority and a tarnished reputation. The fundamental question this case raises, has no easy answer. It's the question Judge Keene wrestled with in his 2 opinions. It's the question that contract law professors debate. It's the question that every business person faces when negotiating deals. How do we balance the need for certainty with the need for fairness? Certainty says, the written contract is the deal. Period. If you sign it, you're bound by it. No excuses, no claims that you were promised something different. This creates predictability. Parties know where they stand. Lawyers can advise clients with confidence. Courts can resolve disputes based on clear terms, without endless battles over who said what in some conversation that may or may not have happened the way people remember. Fairness says, sometimes the written contract doesn't capture what the parties actually agreed to. Sometimes one party has more leverage and dictates terms. Sometimes promises are made that don't survive the drafting process. Sometimes parties deliberately create ambiguity to trap their counterparties. In those situations, strict enforcement of the written contract produces unjust results. The law tries to walk a line between these competing values. Integration clauses lean towards certainty. Doctrines like fraud, misrepresentation, and subsequent oral modification lean toward fairness. The result is a system that's neither perfectly predictable nor perfectly equitable. It's messy, case-specific, dependent on facts and judicial discretion. That messiness frustrates people. Business executives want clear rules. Lawyers want reliable precedents. But maybe the messiness is necessary, because human relationships, even commercial ones, are themselves messy. They involve trust and deception, good faith and manipulation, clear communication and deliberate ambiguity. The law has to be flexible enough to handle all of that. The final word, page 17, section 12. 9 lines of standard boilerplate that nearly ended Thomas Harborline's company. An integration clause that seemed routine when it was drafted, but became a weapon when the relationship fell apart. That clause said, "This contract is everything. Nothing before it matters. Nothing outside it exists." And for a while, that clause worked exactly as designed. It got the case dismissed. It protected Northbridge from claims based on Marcus Venn's promises. It turned handshakes into legal irrelevance, because that's what integration clauses do. They draw a bright line and say, on one side is the contract, on the other side is everything else, and the law only cares about the contract. But then came the subsequent oral modification doctrine, a principle from a 1978 case that most lawyers had never heard of. A doctrine that said, even integration clauses have limits. Even written contracts can be modified by subsequent conduct. Even bright lines can blur when both parties act as if they've changed the deal. That doctrine, applied carefully by Judge Keene after reconsidering his initial ruling, created space for Harborline's claims to proceed. It didn't guarantee victory. It didn't mean Northbridge was liable. It just meant the case deserved a trial. That the evidence of post-contractual promises and conduct was strong enough that a jury should hear it. The settlement meant no jury ever did, but the legal principle survived. Judge Keene's opinion remains on the books, available for future parties facing similar situations. A reminder that contract law, despite its emphasis on written terms and formal requirements, still has room for equity, still has mechanisms to address bad faith, still recognizes that sometimes what parties actually intended matters more than what they technically agreed to. Is that the right balance? Reasonable people disagree. Some say Judge Keene went too far, that he undermined the certainty integration clauses are supposed to provide. Others say he didn't go far enough, that he should have been willing to look at pre-contractual promises too, when there's clear evidence of fraud. The debate will continue because it touches something fundamental about how we think law should work. Should it be mechanical, applying clear rules to written documents regardless of context or consequence? Or should it be equitable, considering the full circumstances and trying to reach just outcomes, even when that requires flexibility and discretion? The answer is probably both somehow. Rules that are clear enough to guide behavior, but flexible enough to prevent injustice. A system that respects written agreements, but doesn't become blind to reality. Harbourline versus Northbridge is a case study in that tension. A buried clause that flipped a verdict. An obscure doctrine that revived a dismissed case. 17 words that mattered immensely, until other words, spoken, written and implied, mattered more. In the end, the law did what it's supposed to do. Not perfectly, not cleanly, but adequately. It found a way to balance competing principles and reach a resolution that, if not satisfying to everyone, at least felt defensible. The conference room is empty now. The lawyers have moved on to other cases. The parties have returned to their businesses. The judge has rendered his opinion and closed the file. But the questions remain. About trust and contracts, about words spoken and words written, about what binds us to each other when we make promises, about whether the law can ever fully capture the complexity of human agreements. Maybe it can't. Maybe that's okay. Maybe all we can ask is that the law tries, that it remains open to evidence and argument, that it doesn't become so rigid in its attachment to rules that it forgets what those rules are supposed to serve. Justice, fairness, a society where people can make deals and trust that if things go wrong, there's a system to make them right. Page 17 contained a clause that almost destroyed that trust, but the law found a way to restore it. Not through magic, not through ignoring the written contract, but through careful analysis of what happened after the contract was signed. Through recognition that integration clauses, powerful as they are, don't give parties license to deceive. Through application of an obscure doctrine that most people had forgotten, but that turned out to matter enormously when justice required it. That's the legacy of this case. Not just the specific holding or the settlement amount, but the reminder that law is human. Written by humans, applied by humans, serving human needs. And when humans are at their best, they write laws that are strong enough to provide certainty, but wise enough to permit fairness. They create rules that guide behavior, but leave room for context. They build systems that respect agreements, but don't become enslaved to formalism. One obscure clause flipped the entire verdict. But in the end, it was people who made the difference. A lawyer who didn't give up, a judge who was willing to reconsider, an expert who explained why doctrine matters, and maybe, just maybe, a legal system that, for all its flaws, still tries to get things right. The case is closed. The story continues. Because somewhere right now, another party is making promises they don't plan to keep. Another integration clause is being drafted that will become a weapon in future litigation. Another attorney is searching through old cases, looking for an angle, hoping to find some principle that will save their client's case. And the law, imperfect and evolving, will be there to sort it all out. Justice isn't always clean. It's not always fast. It doesn't always feel like victory even when you win. But it's what we have. And in the case of Harbourline versus Northbridge, it turned out to be enough.